Today, I am going to discuss Chapter 1 of BC Real Estate course, Fundamentals of Law. Before diving into the fundamentals of law, let's discuss what is law. Law is a set of rules which govern a community, state, and/or a country. Now, let's talk about what are the sources, origins of the law. Where do the laws come from? The first is common law. In old days in England, when people used to have disputes, they used to go to the king and king used to give the judgment. King then appointed judge and courts to do the judgment. So, the decisions of those judges from the old cases became the source of common law. Hence, common law is also called as court-based law or judge-made law. Important concept in common law is stare decisis, that means let the former decision stand. This means any case with the same precedents and actions will have same judgment, which establishes certainty in cases and uniformity in the law. Next, let's discuss equitable law. So, sometimes the decisions made by the judges in old days were a little harsh and people used to turn to the king to petition, and as more and more people turned to the king appointed chancellors to deal with those judgments with some equity, fairness or justness. So, the laws provided more equity and fairness, which came to be known as equitable law. There are three remedies granted by courts of equity. 1. Specific performance. This means to perform the contract. For example, if two parties, say S, seller, and P, purchaser, enter a contract in a real estate transaction and the market goes up before the closing and S refused to sell the property at older prices, P can go to the court and judge can order remedy of specific performance to S to complete the contract. 2. Injunction. This means to do something or to not do something, that is, action. 3. Quantum meruit, as much as one deserves, a fair amount for the work done. Third source of law is statute law, the law that is created by government representatives at federal, provincial and municipal levels. So, why it was created? There were judgments in common law, equitable law that were no longer valid, justified. So there was a need to change the common law, and there were areas of disputes that were not touched by common law, and therefore statute laws were created. The Constitution provides powers to federal and provincial governments to create laws, whereas municipal governments or bodies do not have powers to create the laws, but the provincial government delegates some powers to the local municipalities, such as to create bylaws like no parking for more than 72 hours on a public street and traffic violations, and so on. Areas under federal law: banking, taxation, marriage and divorce, criminal, copyrights, patents, fisheries, shipping and national defense. Areas under provincial law: property and civil rights, education of the province, leftover areas not covered in federal law. Now, what kind of questions that can be asked in the exam? 1. Meaning of state decisis equals let the former decision stand. 2. Priorities of law: statute, then equitable, then common. 3. Remedies of equitable law: specific performance, injunction and quantum meruit.